Your voice seems to be very low. I can't hear you. Sorry, what was that?
Is this one better?
Yeah, this is better. This is fine.
Okay.
Yeah, there we go. Right. So, okay. Let's begin to this today's session, and let me just bring up the document that we can be using today. Right. So, how was your week? Did you have a good week? What did you
It's
do?
been. Sorry?
What did you do the entire week? Were you studying or?
Yeah, mainly studying. Exams are coming soon, so.
Oh, nice. Which
Well,
exams?
I have real estate, family law, and then access to justice.
Real estate. Right. Is it land law or is it like real estate conveyancing or anything?
Real estate conveyancing,
Oh shit. But that's good. I mean, we've got so today it's we're diving into conveyancing, the sale part of it at least. So it would be very helpful. Let me have a look. Where is that document? So, are you aware of the national protocol, the conveyancing protocol? Do you
What
know
do you
what that
mean?
is?
What do you mean by that? Sorry.
So okay. So when we involved in the process of conveyancing as solicitors or as conveyancers, we abide by a protocol.
Hmm.
That protocol is just an undertaking that we undertake to say that, oh, we are going to abide by that protocol, saying that we we will not go into detail of the property, such as inspecting the property or such as doing this or doing that. We just stick to the legal aspect of land law. And if there's any issues with the legal aspect of land law or land or that land in question, we just dive into that, and that is it. We will not look at the things such as which are subject to inspection,
Hmm.
on ground inspection. So we will not be looking at those things. And when once you abide by that national protocol, that is when the conveyancing process becomes technical and easy as well at the same time. So let me just take this document out. Right, should have been here. Hmm. Mhm. So can you Google the conveyancing protocol as well? Can
Yeah.
you?
Just.
Yeah, it would just take you onto the Law Society's website. Um, did you find it?
Yeah, from the Law Society website.
Yep, that's it. So we've got. Where is it? Yeah, there we go. So if you just download the Conveyancing Protocol 2019 document,
Mm-hmm.
right. Do you have it in front of you?
Yeah.
Perfect. That's fine. Now let us share this screen. Do you mind sharing your screen with me so I can have a look on the protocol as well?
Yeah, just one sec.
Yeah, noise.
It's not working.
We're not able to share screen.
No, I don't think so. It's not letting me.
I do have that option though. It's here. Right, can you see my screen?
Yeah.
Perfect. That's fine. Right. So that's fine. Yeah. So can you see this? Are you able to see this, the Law Society document?
Sorry, it's gone now. I can't see it anymore.
Okay. Let's just. Hmm. Can you see the screen now?
Yeah.
Perfect. Now can you see the document?
Yeah.
Okay, perfect. So this is the protocol that basically is for any solicitor or any conveyancer that is undertaken to basically do a property transaction. Usually, law firms do abide by this protocol. You would rarely see any law firm not abiding by this protocol. So this protocol is really important in terms of your practice. Now, let's go through. Right. So, what is the objective of this protocol? Number one, to ensure that the transaction can proceed smoothly. And then what you should do is you should ensure that all information is shared, subject to any confidentiality obligations that have not been waived. Ensure that you have managed and covered timing and other expectations and link transactions such as chains appropriately. Do you know what a chain transaction is?
Is if there's more than one transaction
Yes.
involved.
So if I'm buying a property, my seller, the seller who's basically selling his property to me, would have another property that he's buying, and so on and so forth. So a chain can be a very long chain of 10, 20 transactions, and a chain can be a very small chain of 1 or 2 transactions, and that's it. So you need to have a look and you need to ask this question at the very outset when you're confirming instructions to. So we spoke about when we're confirming instructions from our client. Once that's done, once you've done the ID check, once you've done everything else, you get into the process of conveyance, and where you're confirming instructions. You're number one identifying who's the party that you're representing. You're identifying the property that you're either representing as a seller solicitor or as a buyer solicitor, and you're also identifying and confirming from them that are they instructed or not. So there are standard letters of every law firm um, of confirmation of instructions. This letter is sent usually by email. Uh, Nobody does post nowadays, but if someone insists on it, that you should send a letter-headed paper confirming instructions and confirming your SRA number, you should do that. It's fine. That's not a problem. Once, so today we're discussing sales only. Um, so as a seller solicitor, um, so I'm just gonna run through a summary with yourself. You read this protocol of the seller solicitors, and you just give me an executive summary of it in writing, saying that what did you understand of it, and with obviously what you're going to do is from now on have a bit of an assignment kind of a thing.
Mhm.
What so what I need from you is a a analysis of this protocol from the seller solicitor side and a buyer solicitor side. Now, so you're the seller solicitor, right? You first have to have if now the ID documents have been done, you've checked IDs, you've checked everything. Now you're into the conveyancing process. The client has paid monies on account. So usually, what as a conveyancer, as a seller conveyancer, you would need around about 50 to £100 on account, depending on uh, what time the transaction is taking place. So if it's taking place today, like at this time when the rates of documents are as such, so you just require £100 or £50 or whatever it is. But if it's at some point in the future, you would require that same amount where you would see that, oh, ID and AML costs this much, land documents cost this much, redemption statements on LMS portal or the Lenders Exchange portal cost this much. Now, there's 3 different third parties that you need to correspond with. Number one is the land registry. That is the most important portal that you can have, along with the lenders portal. So the land registry portal is a portal designed for conveyancers to have documents that have been uploaded, that have been registered, and that is within the records of the land registry. Now, these documents are very important because they deduce title. So, if what does deduction of title mean? It actually means that you are the proprietor, which you of the property which you claim that you are. So, if imagine a tenant or a rent, so a tenant basically, not a tenant in common, not a joint tenant, a tenant, a simple tenant who's paying rent. a monthly basis. He comes to you and he says that he wants to sell a property where he's tenanted. How would you check that this person is the proprietor of this property and he has that right of further disposing of that property? How would you check?
So you can look at the official copies, and
There we
there's
go.
a proprietorship
Yes.
section.
So wow, I mean, you know what I'm talking about. That's good. So yes, you would check the proprietorship register and see if, and at some point you might think that, oh, okay, that he's one of the proprietors. Let's talk about a tenant in common. He's one of the proprietors, but there might be a restriction down at the bottom saying that no disposition of the registered estate can be done, blah blah blah, without the consent, without the joint consent of these people, the proprietors, or with an order of the court, or while the person is acting on a trust or something like that, of some wordings, which would restrict one of the tenants to sell off the property and sell the interest of the other tenant in common as well. So there is a restriction. Yep. Now, the office copies are a very important document. Number one, they, as we said, they deduce title. They say that who's the registered proprietor. Yep. Number two, they tell you they identify the property. So the title plan is very important. The title register is very important. And then what else is important is, are the documents mentioned within that title register? It may be a conveyance, it may be a transfer, it may be a deed, it may be an agreement, it may be a lease as well. All four of these are very different to one another at times. So, what's the difference between a deed and a lease? What's the difference?
Deed. So a deed is obviously it's like official, so it goes through the process of obviously being signed, witnessed, and delivered. And then a lease is more of an agreement between the landlord and the tenant.
Mhm. Are you sure? What's
From my
the
understanding.
what's so if you go on Google, type what is a lease as per English law, and let me know as well because I've forgotten this as well. It's a very conceptual question.
So what is a lease for English law?
Yeah, under English law.
So it says here, under English law, a lease is a contractual agreement granting a tenant exclusive possession of the property for a specific period in exchange for rent, creating a leasehold estate in the land.
There we go. That's fine. So I think what you said, that's fine. Right. So you've got these four different documents coming up, and you'd have to download them as well. Yeah. Now, bear in mind we're representing these sellers, so these form part of the protocol documents. Now, these form part of disclosure as well. So once the sentence that we read is that, I mean, anything that forms part of full disclosure, you need to disclose them to the other side, because it might contain a covenant or a restriction or a right that's reserved or a right that's granted that would not be within the title register itself, but in that document, in that very document that's mentioned there. So you've downloaded the office copies. Usually what people do is they download office copies and they only download the title register and the title plan, and they leave out the lease. Sometimes they don't, but they leave out any deeds mentioned within the title register. They leave out conveyance. They say that if it's asked by the buyer solicitors, we'll provide them. But if it's not asked by the buyer solicitors, we'll not provide them. Now the issue is that the buyer solicitors, they're solicitors as well, and their experience, and they will definitely ask for those documents. So why not provide them in the very outset? Yep. I mean, it just saves time. So to save time, number one practice is to have full disclosure, not of communication between you and the buyer, sorry, you and the seller, until unless the seller says that, can you just please disclose this and can you just please say this or that? Not that, but the only things, the documents that are mentioned within either the TA 30, sorry, TA 6, TA 10, or TA 7, or any other documents, the title documents that you have. So if, for example, in the property information form, so there's three documents that are very important: the leasehold information form, property information form, fittings and contents form, and the completion undertaking. That is the TA 13. So all these four documents, they serve a purpose. Now they form part of the protocol as well. So if a person in the property information form, do you know what a property information form is? Yeah, right. So a property information form would have information about a property, about that specific property, of what the structure contains. So if you, for example, you have this property, look here. If this is the property, yeah, this is just like this, yeah. If you put it upside down, anything that sticks to this, to the palm of my hand, which is the land, is basically whatever needs to be disclosed within the property information form.
Right.
Whatever falls from this needs to be disclosed within the fittings and contents form. The fittings and contents can be a washing machine, a washing machine. It can be a boiler. It can be a bed. It can be a curtain or something like that, or something of that sort. So anything that does not stick to the property, to the structure of the property, once it's upside down, is what comes in the fittings and contents form. And the leasehold information form, again, from its name, it's very clear. It talks about the lease. Who's the management company? Who's the managing agent? What's the service charge? What's the ground rent? What's the rent? I mean, the financial obligation, it talks about that. It talks about other obligations. It talks about reservations. It talks about exceptions. It talks about rights and all of these kind of things, which you'd find in a lease. So imagine if a person is paying rent, a ground rent for the property, he would mention that within the leasehold information form and not in the property information form. Although the property information form may contain a section where it says that this, but the leasehold information form is more relevant to that section. Right. So now the documents that we spoke about, protocol documents, are the number one. If it's a freehold land, you do not need a leasehold information form because there's no lease. There might be a lease of minerals or of other things, but that does not form part of, until and unless it's mentioned within that lease, and there is a management company having occupation or having control of that specific land of the property. You do not need a leasehold information form generally. There may be special circumstances where you do. You need to check. Again, you need to have a look. So the protocol docs would contain, now again, we're talking about from the seller solicitor's perspective. Um, Number one is the forms, whichever are relevant to this transaction. So what you do is you download these forms, you'd fill out the relevant information, and you'd send it to the client in the first instance. Once you send it to the client, because you cannot give that undertaking about that property because you do not know about that property. Yeah. So you would fill it out. The seller would fill it out, the property information form and the fittings and contents form, and he'd pass it back to you. You'd save it on file, and in the same instance, you would do the completions undertaking form, which is the TA13. The TA13 is basically stating information about completions. So once you're in completion stage, what's going to happen? It is what is mentioned within that form. So are the keys going to be left with the estate agent, or are they going to be left with yourself, or are they going to be left with the seller? And then where is the completion going to take place? Which charges are to be discharged? Are there any restrictions that need to be discharged? What's your bank details as a seller solicitor? Because the buyer solicitors cannot get in touch with the sellers. They cannot transfer funds directly to the sellers as per the protocol. So, and so on and so forth. This basically is an undertaking by the uh, seller solicitors to say that this is how completion is going to take place on the day of completion. So, which documents are now forming part of this protocol docs? Number one is the protocol documents itself, the TA6, TA10, and the TA13. And then we've got the title documents. And then we've got the contract. So it's usually the seller solicitors who do the contract, and the buyer solicitors do the transfer. They draft up the transfer. What you basically can do, I mean, best practices, nobody's stopping you from that, is you do the transfer as well. So as a solicitor, you can do the transfer yourself. There's nothing stopping you within that protocol to say, oh no, you can't do it. You can. It just speeds up the process. Right. So all of this forms part of the protocol documents. Any questions?
So far, no.
Perfect. So within the property information form and the fittings and so what's the purpose of the property information form? As you said, that it would contain information of the property which forms part of it, part of the structure. Now, if there's been any building works, if there's been any replacement of windows, doors, or anything else of a meaningful nature, that would be within the property information form. The property information form has other documents along with it. Those could be certificates of building regulation and compliance certificates. Those could be planning permissions. Those could be maintenance logs. Those could be anything which the seller is relying upon. If they've installed something, then they need to have a legal document as per the protocol. Not every document is important. So, for instance, if the property is not tenanted, and the property was never tenanted, you do not need an EICR report, which is the electric um, sorry, was energy something certificate report. Oh, sorry, wait. Let me just have a look. EICR, I just forgot it now. EI. So, yeah, so it just is a Where did it go? Yeah, so electrical installation conditions report, which basically is that so if a property is tenanted, you need to have some documentations in place, like an EICR report, like an EPC, not below the level of, I think, G or something. Or no, sorry, not below the level of, yeah, I think it's G. And then some of the documents as well. A gas safe certificate as well. If there's a gas operated boiler or if there's a gas operated stove or anything of that sort. So all of these form part of supplemental documents to the property information form. Now, what's the purpose of a fittings and contents form? It would just include, as I said, things such as beds, curtains, or these kind of things, and it would also serve. So the only thing that you need to look in a fittings and contents form is there a price mentioned with the fitting or the content that's been added to the property. Like if there's a bed, is there a price to it? So there would be a section. So if you can you just type in for me? Let me just let me just show you what a fittings and contents form would look like. Fitting and contents form. So this would, yeah, there we go. Can you see my screen?
Yeah.
Yeah, perfect. Right. So this is the Law Society fittings and contents form. And you need to make sure that it's the latest edition. You can go onto the Law and Society website and see that this is the latest edition. Now, there we go. So basic fittings. Now this is for the seller to fill in. If it's included, he just tick yes. And he can state the price and say, I mean, it is for £4,000, and he can add a comment about its condition or anything of that sort. And all of this goes to the buyer solicitor and to the buyer as well. This, if it includes a price to it, it just forms part of an inventory. Now the inventory serves as like a shop, like everything that's included, but it's got a price. So if it's got a price, I mean, are you willing to buy it? If the buyer says, no, I'm not willing to buy this, I don't need it, remove it from the property, the seller has to remove everything from the property then. Basically, anything that he does not want included within that property, the seller has to remove it, exclude it from the property. Because the perception is that the property, again, would just come in the condition of the upside down condition. Anything that's added onto it may include a price, may be up to further agreement between both of the parties. Now, all of this, you've prepared this as the contract pack. You've prepared the contract as well. So you've got different softwares that nowadays do that. You don't need to prepare the contract from the very start. So you don't need to prepare the structure of the contract or anything else. What you need to do is, so you've got softwares like Proclaim, you've got softwares like advanced software like softwares like Leap, and others as well, where you just put, so you have screens. When you go into screens, you have buyer's details, buyer solicitor's details, seller's details, property information, title information. So you put in the title register, you put in the property address, you put in your details, your solicitor's details. Your details as solicitors, your client's details, the buyer's details, the buyer solicitor's details, and it would just save on that screen. And it would so you'd have the screen known as draft contract. You just click on that, and it would instantly suck all of the information from Proclaim or any other software, and it would just put it into the document, the draft contract. So you don't need to do anything with that draft contract. You just need to basically click and draft contract. There you go. That's the draft contract. But it's still up to further agreement. And the only place where they'd raise inquiries and they say they'd request for amendments is number one, um, the first page of the uh, contract, which carries the information of the seller, the buyer, the property, the purchase price, and that's it. So the parties, the purchase price, um, and you've got the any of the details. I don't think, no, you don't need any of the details for that. Regarding amendments, the second page is general conditions. So they may be fifth edition or something like that, or any edition edition of the contract that you're basically using, and the buyer solicitor obviously is using, and it should be an up-to-date version of it. And then you go on to the third page, which contains special conditions. Now, these special conditions are usually 8, but they can be lessened depending on the transaction. So let me just go through these conditions with yourself. Let's just see if you have a draft contract. Draft contract. Might have it here somewhere. Yeah. Have to have a look of a contract, which basically doesn't have any information of a client. Let me just Google it. Let's see if you can find one here. Come on. Oh, there we go. I think that's. Oh. So, as we're doing a residential one, so this is going to be a standard contract. Right. Can you see this now?
Yeah.
Perfect. So, for conveyances use only. Now, this is basically nearing completion part, so you don't need to bother yourself with this right now at this minute. This contract basically this is the first page. So this is the date of the agreement. Once you've agreed a date of completion, on the date of completion, this is the date of the contract. Now, the date of the contract and the completion date can be different. So the date of the contract can be, so that's when the exchange happens. So the date of the contract can be 10th of April 2025, and the date of completion of this transaction can be the 20th of April. And that the agreement date is the contract exchange date. So you'd write here the exchange date of the contract. The completion date is separate, as we spoke. So it's something to do with completion. That is a separate topic. Now, date, you date it of the date of the agreement. The seller, obviously, it's your client. The buyer is the buyer that you're basically he's buying from yourself. Property, if it's freehold, you basically delete the leasehold part and you put in the freehold property known as this, edged red on the title plan, this having title number this. Yeah. And title number, root of title. So the title number would come here. Special encumbrances. It's usually a standard format which different law firms have. It's usually standard within their contract, so you don't need to worry about that. Title guarantee. So the title guarantee is basically got to do with if what is the knowledge of the seller, the knowledge base of the seller. So if he's selling as an executor, he might have limited knowledge of that property, thus having limited guarantee of the title. So he cannot guarantee that this title is basically, or this property, what this property curtails or it entails, or what does this property have? That is a limited title guarantee. Now, a full title guarantee would usually be seen where the person is the actual seller. He's named in the proprietorship register and he can basically give you a full title guarantee. Completion date, as we said, is the date when the funds are transferred, the whole funds are transferred onto the from the buyer solicitors onto the seller solicitors, which is yourself, and you basically transfer it after deducting your fee and everything from that sale price, and then you transfer it onto the seller, and then you've got the deposit, which is basically usually 10% held to order. But that's just a phrase used nowadays because I've not seen a transaction where you had to keep 10% and you had to actually transfer it onto the seller's solicitor's bank details. It can be the case where 10% is deposited to basically lock in the transaction, but that is not to say that it's been done or it is done. Usually it's the funds come in on completion date and they're basically transferred on completion date and all of it. And once you're exchanging contracts, you just say 10% held to order, the other party agrees. If you say as the seller solicitors that can you transfer the 10% just to lock in the transaction, they are bound to send you that 10% of the purchase price. Uh, and then you've got contents price. So we discussed about the fittings and contents form, and we said that the fittings and contents form has a price mentioned there. So this would be here in contents price. So if anything is included with the property and there is a separate price to it, it's included here. And the overall balance would have contents price plus the purchase price. So you'd put it here. Now, these are the standard conditions of sale, fifth edition. You just need to make sure that um, um, these are up to date and you're not using the previous standard conditions or any outdated standard conditions. And then you have special conditions. Now, these special conditions should have the contract number one. The contract incorporates the standard conditions of sale. The terms used in this contract have the same meaning when used in the condition. conditions. Subject to the terms of this contract and to the standard conditions of sale, the seller is to transfer with either full title guarantee or limited title guarantee as specified in the front page. Now, these are all special conditions you can have a read in. If you have any questions, just let me know. This is a very important bit. So if the property is being sold as vacant possession, this needs to be in the contract that the property is sold with vacant possession. If the property is not being sold with vacant possession, the property is sold subject to following leases and tenants or tenancies. They need to mention it. Sometimes the property is not vacant, there is a current tenant in it. So if you have a lender, so that, oh sorry, that's the buyer's part. We discussed that once we're using the buyer's side of the transaction, so it's relevant to that. But if the buyer solicitors say that we need this tenancy to be finished, we need the tenants to be evicted, you are bound to evict the tenants, because if you do not, or if your client does not, you're at a position of a stalemate, or you're at an impasse where the transaction can fall through or the sale can fall through, because maybe the seller is not looking for the buyer is not looking for a tenancy within the property. He wants the property for himself. He's not buying the property as a buy to let. He needs the property for himself, so you need to make sure that the property is basically not tenanted, if that is the condition of the sale to go through. Now, conditions 6.1.2 and 6.1.3 shall take effect if the times specified in them were rather than 2 p.m. Now, 6.1.2 and 3, let's have a look. What does it say? So 6.1.2, if the monies due on completion is received after 2 p.m., completion is to be treated for the purposes only for condition 6.3 and 2 as taking place on the next working day as a result of the buyer's default. Condition 6.1 does not apply when the seller is treated as default if the sale is with vacant possession of the property or of any other part. The buyer is ready, able, and willing to complete, but does not pay the money due on completion until after 2 p.m. because the seller has not vacated the property or that part of by that time. Now, usually, this is the 6.1.2 as far as I've seen, and 6.1.3 as far as I've seen, is used where there's a chain of transactions. It can remain in other circumstances as well, but in my experience, this only stays there until where there is a chain transaction involved, and then if there's an occupier, then you need their consent, and then you just put in your details and the buyer's details as well. So basically, with that, you have prepared the contract pack. Now, this contract pack needs to go with your letter on your letterhead saying that, number one, you need to identify the property address. You need to identify who are the parties to this transactions. So it would be the seller and it would be the buyer. It's best practice to include the seller's full name in the contract and in your letterhead document, because once the transfer is being prepared, you need to have the full name of your client, because it can be raised as an inquiry saying that we need a conveyances certificate or a statement of truth to say that the person within the title register is the same person who is selling the property. So if you're missing a middle name, such as if my name is Mohammed Usman Zahir, now but my actual name is Usman. My given name is Usman, but my first name has a bit Muhammad within it. So if I don't include Muhammad, and if I just type in Usman Zahir, and in the title register, in the proprietorship register, it says Muhammad Usman Zahir, the buyer solicitors would automatically say that, can you please provide a conveyances certificate or a statement of truth that this person who's selling the property is the same person who's basically within the title register. And that could create a back and forth, which would basically, waste time. So make sure once you have the documents, the passport or the UK or a UK driver's license of your client, make sure that you include all of the names given in that document, and you do not type in M Usman Zahir or just Muhammad U Zahir. So type in all of that within. So once you've prepared that, so up till now, what documents have you prepared? Can you tell me, please?
So we've prepared the standard form. So, for example, the fittings and contents form. Sorry, the property information forms, and then we've done the contract forms.
There is no, it's no contract form. It's the contract
The
that
contract,
you
yeah.
need. Yeah, that's not a form. That's the contract.
Yeah.
So you need to prepare the so the fittings and contents, property information, and the completion undertaking. It's best
Mhm.
practice to send the completion statement as a completion undertaking as well, um, with the protocol documents. So three documents from the protocol, one contract, and the title documents,
Okay.
along with supplemental documents, as we said, any maintenance logs or any other things that the seller has relied on. So you put that in an email. Nobody does posts nowadays, so nobody wants you to have basically a bundle of documents in a post, in a parcel, and having that sent across. You don't need to do that. Because everyone's going paperless. Conveyancing industry is moving towards paperless, so the best practice is that you move towards paperless as well. um, Whilst you've done that, you need to look at the title register if there is a charge on the property from a lender. If there is a charge on the property, then you need to ask for a um, mortgage statement from your client, for asking for a redemption statement from the lender. Does that make sense? So if the mortgage is with any lender, you just go. So you've got two panels where all solicitors or all law firms are on. Number one is the lenders exchange, and number two is LMS. And you've got all of the documents that a conveyancer should rely on these two portals. So you'd have your own login as a fee earner, and you'd basically just go into these and type in the name or the mortgage account number and just see if there's any document that you've received. The redemption statement is usually applied for. So you can apply for it through Lenders Exchange, or you would need to get in touch with the lender if they have a separate process in place, such as sending them an email or giving them a call or just writing to them on your letterhead paper. So that's one part of the transaction that you've done. So one stage of the transaction, sending the contract back. We did the first part, which is identifying the client and confirming instructions from the client, having monies on account. Now you're on to the other stage of the transaction, which is the conveyancing part of the transaction, sending the contract back out and checking if there are any issues or any discrepancies within the title register. Either the client is unidentifiable, or there's a lender involved, or there is a charge on the property that you need to deal with, or any other thing that the documents that you have would identify within itself. So I think that's enough for today. Do you want to continue with the process, or I mean, is it too much information to?
It's definitely, obviously, it does align with my studies, but obviously, like, with what you said from more of the seller side, my studies focus more on the kind of buyer side. So I think I'd go over the recording and review this, and also kind of, look at the protocol itself.
Yes. So what you need to do is the protocol. You need to start with the seller side. So
Mm-hmm.
what I need you to do in the coming days, once you're free or whenever you're free, is to draft a document for me to say that to what we've studied, what is the protocol for this? What is the case law for this? If there is any development within the case law. So if there is a case discussing about a specific part of this protocol and saying that you need to do or you need to do this or you need or such as the caveat emptor issue like buyer beware. Yeah. So what I think there is a developing case law on buyer beware as well now that and I was reading about it, but you still need to look into this. So just go through the protocol till we've where we've studied and let me know, draft a document for me for best practices. What are the best practices for today's conveyancing? You need to include laws, you need to include policies, you need to include judgments as well. This would give you a better idea that the conveyancing process, how does the conveyancing process work? So usually what conveyancers nowadays are doing are a tick box exercise, which I call, or a lot of other conveyancers call as monkey conveyancing. You don't need to be a monkey. You don't just need to sit on a laptop and say, oh, this is a checklist that I need to go through. Tick, 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 and we're off to completion. No, because you can miss a lot of things within that process. And it is the liability that a lot of solicitors are looking forward to. And then they're like, oh shit, we shouldn't have done that, or we should have had a trained person who's basically CQS trained. So, yeah, there we go. Now, what you need to do is get through the protocol till we've done it, uh, draft up a document with best practices and recommendations. Yep.
Yeah.
And what's the deadline for this assignment? What do you want the deadline to be?
I can try and get it for next Sunday, but if not,
Okay.
then past that.
Yeah, that's fine. No worries. That's fine. I mean, yeah, whenever you're free again.
Okay.
Yeah, that's fine. Okay, then. Any questions?
Not so far, but if I have any, I'll message you about them.
Perfect. Yeah, that's fine. All right, then.
All right.
Thank you,
Thank
Erica,
you.
to
Thank
to
you.
be here today. Yeah, and I'll see you next weekend.
All right. Bye.
Bye.